For the third time, a divided Supreme Court will consider the Texas law that has stopped most abortions in that state. This time, the court is not ruling on the law's constitutionality but deciding whether abortion providers and the Biden administration can sue to block it in federal court. The justices will hear 2 hours of arguments Monday on the thicket of procedural questions that have thwarted advocates of abortion rights and kept in place the state's strict new limits on abortions. While the lawyers will argue over procedure, the overriding question is whether the conservative court will stand in the way of a state's bid to stop abortions. So far, the answer has been no. The Texas Heartbeat Act, also known as Senate Bill 8, says it is illegal to perform an abortion after about 6 weeks of a pregnancy but gives the state no direct role in enforcing that ban. Instead, it authorizes private lawsuits in state courts against doctors or clinic owners who violate its provisions. On September 1, 4 members of the High Court, including Chief Justice John G. Roberts Jr., voted to block the Texas law before it took effect, but they were unable to win over at least one more conservative to form a majority. 2 weeks ago, the justices weighed the issue again after the Justice Department entered the case, but they agreed only to hear arguments on the procedural questions. U.S. Solicitor General Elizabeth B. Prelogar, who was confirmed last week by the Senate, called the Texas law an affront to the Constitution, as well as to the Supreme Court's role in protecting the rights of Americans. Texas's various procedural objections do not withstand scrutiny once S.B. 8 is recognized for what it is, a brazen nullification of this court's precedents, she wrote in a brief filed Friday. Texas is responsible for S.8. and it is subject to this suit by the United States and an injunction by the federal courts. Prelogar's argument rests on the idea that federal law is, as the Constitution states, the supreme law of the land. Yet throughout its history, the Supreme Court has shielded states from being sued directly. States are said to have sovereign immunity unless Congress has acted to waive it. After the Civil War, however, the Reconstruction Congress passed the Civil Rights Act of 1871, which authorized suits in federal court against any person who, acting under color of state law, deprives others of their rights protected by the Constitution.